On Human Services, excuse me. The House Committee on Human Services will now come to order. The clerk call the roll.
Chair Frank,
Here.
Vice Chair Rose,
Here.
Representative Glick,
Here.
Representative Shaheen,
Here.
Representative Ramos,
Here.
Representative Noble,
Here.
Representative Campos, Representative Hull, Representative Manuel.
Quorum is present. Chair lays out as pending business House Bill 1141 by Cortez. And we will resume hearing. Chair calls Karen Ray, the resource witness from HHSC. I don't know if we need to do this again, but I've got you listed as Karen Ray from Health and Human Services on the bill. Is that correct?
Ray from Health and Human Services on the bill.
Okay. And did you have any other comments from your earlier testimony?
I did, actually. I wanted to follow up with Representative Ramos on the 25% number. I took the opportunity during the intermission to go back and look at the fiscal note and compare it to our agency cost estimate. I see 25% in the fiscal note, but it's not in our agency estimate. We didn't estimate the number of employees who would use who we thought would use the expanded process. Our estimate was just based on the number or the increase in the number of employees to whom the process is available. So I'm not sure where that 25% came from. I can make a guess based on the increase in the number of employees and the number of grounds, but I don't know the methodology there.
Well, because it says, oh, I'm sorry, may I?
Oh, yes, Representative Campos.
Ramos.
Dang it. And we switched that.
See, that's why you need to keep us where we were. It says the analysis assumes 25% would file a formal complaint.
And I think it assigns to that 25% number something like 4,700, and I'm not sure how that relates to the number of HHSC employees overall, because that's closer to 38,000.
Okay, thank you.
I'm sorry for the confusion there.
Thank you.
Thank you, Representative Ramos. Members, any other questions? All right, thank you very much. Chair calls Tyler Sheldon, with Texas State Employees Union. We've got you listed as Tyler Sheldon with the Texas State Employees Union for the bill. Is that correct?
That is correct.
Okay, thank you.
Great. Thank you, Chair. Thank you, Vice Chair. Thank you, committee members. I was this close before you guys went to the floor.
Yeah, I missed it.
But I very much appreciate the great conversation around this bill. It's definitely an important issue, and I know that a lot of times when you're deliberating a bill, one of the first things you ask yourself is legislation necessary to do this? And I know that we saw in the testimony from the resource witness that when the changes were made to the grievance procedure, the only employees that were protected were those protected by statute. They only retained the grievance procedure for state hospital and state supported living center employees because that was included in statute. They were statutorily protected and guaranteed a grievance procedure, so they're the only ones who remain there. So state hospital and state supported living center employees have a grievance procedure that is formal. It has a procedure with an administrative law judge that they can go through. And we think that would be fair for all employees of Health and Human Services and DFPS. That's how it used to be before the changes were made in 2017. So some of the big changes that were made when they implemented this change in 2017 is in Human Services, over 4,261 supervisors were made completely at will, and 16,763 employees lost their grievance procedure. In DFPS, that was 933 that were made completely at will, and 12,789 that lost their grievance procedure. I know that in the discussions currently, some of the concerns that were made by the agency was the expanding of the scope of the grievance procedure. However, I know that another thing that has been been addressed over and over again in all your various committees is the high turnover within the state and within state employees. And I know that some of the stuff that comes up over and over again is the working conditions and the hours that they work as a key driver of turnover. So being able to discuss that through a procedure within Human Services and with DFPS allows the agency another avenue to really assess why people are leaving and how they can, what they can do to be able to change the policies within the agencies there in order to retain and recruit staff so that we are able to better serve the public within Human Services and DFPS and save the state money on turnover. Turnover has gotten incredibly expensive. I believe over $1 billion a year is spent on turnover. So a fair grievance procedure promotes a strong workforce and allows employees to discuss anything that comes up with a job without having to resort to a lawsuit against the state. So we strongly encourage you all to pass this bill, and we thank you all for your time and consideration.
Okay, thank you. Members, any questions? Yes, Representative Manning.
Do you think this bill would help boost morale to allow people to want to stay longer or to come in if they felt there was a grievance process that was fair across the board?
I do, yeah.
And do you think, for like yourself, would you stay in an agency longer if you knew that what right now currently you could be fired for and you wouldn't have a process, but under this law it would allow you to still be able to feel you could defend your job or position? Would that be helpful?
I believe so. I know that having a workforce that listens to you and that you can discuss anything without being wrongfully terminated or having that fear that a rogue supervisor could terminate you for anything. I know that some of the concerns we've heard is not attending functions after work may be looked down on and could be wrongfully terminated. There's a million different reasons that you might need to be protected against some sort of discrimination and have that avenue available to you to kind of move up the chain. And I think that this would provide that kind of security blanket for employers.
Thank you so much.
Have you had any wrongful terminations in the areas that you're on? I mean, just obviously not names, but I mean, are there people that you work with that you feel like have been terminated? They were doing their job, and you mentioned rogue supervisors. They just come
So
in.
there are a couple instances that I have become aware of through our organizers that are in the field that with our members. I know that there's
nobody that you've worked with.
No. I don't work directly in the field very often. I'm here with you guys.
Oh, okay, that's fair. Because we say at will,
Yeah.
but there is still termination procedures. Nobody shows up. I mean, really I say sometimes the real world, in the rest of the world, at will means you show up, you can lose your job. You can also show up and leave your job anytime, right? Employee can leave, employer can leave. It's at will. It should be mutually beneficial. They can't, even under current law, nobody can come up and just fire somebody.
I think as long as they write a reason that's legal on the paper, but that's not always the case. You can give the reason, but just because you write that on there, if you went through a further process, you may be able to get down to what it was actually the termination was about.
Okay. I was just trying to figure out, because I know, as we say at will, that sounds no protection, and there are processes in place for reviewing that, I believe. But I really am just curious. So, members, any other questions?
I do.
Yes, Representative Ramos.
So to be clear, Mr. Sheldon, what you're saying is that in terms of the grievance process, whether it's at will or not, this allows for there to be a dual conversation or a two-way conversation in terms of why I'm being reprimanded and what they're saying I'm being reprimanded for, or whatever the case may be. This simply allows for there to actually be due process in terms of whatever reprimand or termination that they're trying to initiate.
Exactly. It provides the due process and the ability to have an avenue to bring that forward if you do believe so. I mean, it's not always going to rule in the favor, but it allows that avenue to have it discussed.
Yes, sir. Thank you.
All right, thank you, members. Any other questions?
Great.
Yeah, Representative Manuel. Okay, we can call him back up. Anybody have any questions for this witness? All right, thank you very much. Chair would like to call up Karen Ray again. Sorry, ma'am, we're going to wear you out. we have you as Karen Ray, Health and Human Services on the bill, correct?
Correct.
All right, Representative Manuel.
I just wanted to refer back to a question you said before we had to take a break. Right now, you were saying if someone is, like, let's say they stole a bunch of copy paper, or that's what they're accused of, you can terminate them, but they can still go through a process. And if something is found out differently, they can come back. What happens to an employee in that situation if, let's say, it was a wrongful termination and you said it could take up to 3 to 4 months for the review to go through? Is that person's job reinstated retroactive with pay, or is it just if they choose to come back, it's from the moment that you all clear them for of any wrongdoing?
To clarify, I think the estimate of 3 to 4 months was from Chair Frank.
Okay, sorry about
I
that.
haven't confirmed that. I don't know.
Okay.
I don't know what our timeline is like.
Thank you.
And I also clarify that was 8 years ago.
Okay, thank you. That's where I
My
got.
comment was that was a discussion from 8 years ago. I wasn't suggesting that's what it is.
Well, I guess the broader thing is,
Yes.
would someone be, this is me not saying anything, let's say it took a month for that investigation, and then it was found out that that was actually not the case, or it was something not, where they should have been terminated. Would they be retroactive from when they were fired, or would it be immediately from when the investigation is complete?
The employee would be reinstated.
Okay.
I'd like to follow up with either the committee or your office on whether there's any difference based on the reason for the termination and the reason for the reinstatement, but the employee would definitely be reinstated.
Okay, thank you so much, and I appreciate that information. Thank you.
Thank you, members. Any other questions for the witness? Thank you very much. I think we're not calling you up again on this bill. At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 1141? Seeing none, public testimony is closed, and the chair recognizes Representative Cortez to close on House Bill 1141.
Thank you, Mr. Chairman, members of this attractive committee. Thank you so much for your attention, and I appreciate all the wonderful questions that were given to the witnesses and the
Speaking
resource
of a grievance
witness.
committee.
You know, we rely on our state employees for all the bills that we pass, all the services that we ask, that we talk to our constituents about. We rely on state employees to execute those and to ensure that they're there for our families that we represent. So I think this is a bill that's important because it allows our state employees to know that we have their back and that no one's going to be wrongfully terminated. We're going to increase morale, as you said, Representative Manuel, in our employees if we can get this bill passed. We're going to give them the voice that they need to ensure that there's a two-way conversation going on. And with that, Mr. Chairman, I do close.
All right, if there's no objection, House Bill 1141 will be left pending. Is there objection? Chair hears none, and House Bill 1141 is left pending without objection. Chair lays out House Bill 2229 and recognizes Representative Goodwin to explain her bill.
Good afternoon, Chairman Frank and members. House Bill 2229 does have a committee substitute.
Yes, I'm sorry. Yeah, the chair, I'm sorry, the chair does offer up a committee substitute for House Bill 2229.
Thank you.
Thank you very much for helping me do my job better. Just trying to juggle things.
See, I bolded that up front just in case.
It's very good, very
Committee
good.
substitute House Bill 2229 is named the Natalia Cox Act in memory of 21-year-old Natalia Cox, who was murdered 2 years ago in her apartment by a man with whom she had only been on 2 dates. The man went to her home, threatened her with a gun, but he was not let inside. 6 days later, though, he returned. At that time, he forced his way in and shot and killed Natalia. Natalia's parents, Lakeisha and Lester, who are behind me today, met with me and shared their tragedy. Together, we hope to ensure no other parents have to go through the pain of losing a child this way. The Natalia Cox Act will provide the information and resources women need to keep themselves safe when confronted by threats of violence. When it comes to protecting women from violence, the system fails us time and time again. In 2021, the year Natalia was murdered, 204 Texans were killed by their intimate partner or stalker. According to the Texas Council on Family Violence, of the intimate partner homicides committed in 2021, 38% of the women killed had separated or ended their relationships. Ending a dating relationship, separating after living together, and filing for divorce have shown to pose the most significant risk for victims. We can and must do better to protect Texas women. My committee substitute would require HHSC to create an informational brochure for victims of family and dating violence about their legal rights and resources available to them. This would include the organizations they can contact for assistance, how to get a protective order, and how to exit a lease and move to safety. The intent is to widely distribute the brochures via contact with law enforcement, college campus officers, medical professionals, landlords, or others. Getting this information to victims of family and dating violence as soon as possible can help them stay safe from further violence. We have received a great amount of support for the bill from first responders, colleges, domestic violence organizations, and healthcare providers. The committee substitute makes a clarifying change. We added stalking, harassment, and terroristic threat to the bill language in order that people experiencing any of those situations will also be provided with helpful resources to aid them in safety planning. The reason being current law, family violence is very specific about dating violence as to the length of time someone has been dating, and so we feel like it may not always reach the people, the victims that need to get the resources. While the notice to victims of family violence is currently in law, it does not include all of the relevant information on rights and resources which would help someone experiencing family or dating violence, stalking, or harassment. By charging HHSC to collaborate with victims' advocates on creating the statewide brochure, we can ensure that all the relevant resource information is integrated and disseminated to everyone who may need it. In addition, HHSC will be able to review and update the brochure in the future, something not currently called for in law. In essence, this is a simple bill that can help in a situation like Natalia's. We have the opportunity to make real change and to save lives across the state. And I did want to also just show you real briefly, different agencies have some brochures. This is one from the Austin Police Department, a lot of fine print, a bit overwhelming. We also were provided one from Dallas, which is a little bit briefer and a little bit more to the point for domestic violence and dating violence. And then this comes from the governor's office, and it is a little more clearly laid out. So we think a brochure that is created by HHSC with the help of the advocates can be better, more helpful in getting the right information to victims. I have witnesses here today, including Natalia's parents, an organization that serves victims, and someone with law enforcement, and I reserve the right to close following their testimony.
Okay, you will certainly have it. Members, any questions of the bill author? All right, thank you very much. Chair calls up Lakeisha Cox and Lester Cox. And we show you Lakeisha Cox testifying for self for the bill and Lester Cox self testifying for the bill. Is that correct?
That is correct.
Okay, thank you.
Thank you, Mr. Chairman and Madam Vice Chair Rose, members of the committee. My name is Lester Cox, and this is my wife, Lakeisha Cox, and we're here to support House Bill 2229. We are the parents of Natalia Cox. As mentioned, she was killed on March 31st of 2021. She was a senior at Houston-Tillotson University, majoring in biology, planning to attend medical school to pursue her aspiration of being a plastic surgeon. Destined to do so much more in the world, she was only scratching the surface of her potential when she was taken. To outline that, we have to go back to day one of her life. When she was born, we saw great things from that day. Her stubbornness and her independence was displayed when she was born, and she would not cry for anyone. They tapped her, they gave her the vitamin K shot, and she wouldn't budge for anybody. She was that headstrong. So we knew we had something special at that point. Another instance was we had her in the crib with some toys, and I had a music box, and most kids would be just enamored at the music box, but we found plastic tools in her crib, and she was behind it trying to see where the music was coming from. And just her spirit, how entertaining she was. We tell people all the time when she was younger how we never cut the TV on because she was our entertainment. She would just put on shows and displays, and that was more of what we miss from her being taken away.
So I wanted
Just
to,
real quick, the chair recognizes Representative Hall is present. Sorry, go ahead.
Thank you.
I wanted to talk a little bit about what she meant to the family and to other people. And so for our family, we always encouraged our girls to be dreamers. So Natalia was the dreamer, and she never ever looked at anything in front of her as a limit. She was always looking at, what is my next step? How do I get there? How do I get better? And that's just the type of person that she was. And whenever if you talk to any of her friends, if you talk to anyone that she worked with, they would tell you, if I didn't believe in myself, Natalia made sure that that she let me know she believed in me and to believe in myself and how to do that. And so she was such a strong woman and such a leader. And she was involved in so many things. At school, in high school, she created clubs. And I remember going and buying things for women. We bought all of the bathroom essentials, and we went and donated it, our time there. That's just the type of person that she was. And we wanted to leave you guys with a little bit of piece of her. And he's going to talk summarize a little bit about what happened. And then we want to talk about how this bill we feel like could really help.
So as stated by Representative Goodwin, guy that she had met been on a date a few times prior. There was some red flags that came up that she took notice of, and it was at that time where the terroristic threat took place, and he showed up at the apartment brandishing a gun and a ski mask, and the police were called. They came out and took a report, and she followed everything. They actually commended her about how knowledgeable she was, that she took all the necessary steps. And as Representative Goodwin had stated as well, unfortunately, time wasn't on the side, and things couldn't get done. Protective orders and so forth couldn't be put in place fast enough. So that's what our bill is speaking to as well, is to expedite that process.
So this bill, I think we stand here today for other moms and other dads and other aunts and uncles in this room who we taught our children all about life, morals. We taught our children values. We taught our children the importance of education and doing things for other people. But what we couldn't and didn't know and have the experience of is, what do you do in a violent situation? What is domestic violence? How do you protect yourself? So we stand here for other parents to have a system that can give someone resources to help them fight for themselves. So if someone knows the right that they can exit their lease, if someone knows they have the right to get help and how to get that help, it's just that one step. It just takes one person to hand that pamphlet and start a conversation that we feel like will change so many lives, save so many lives. And having one standardized resource across the state for everyone to get the same help, to get help, what help looks like, we feel like will change lives. And we are this voice for Natalia because she's not here for herself, but for other parents and other possible victims who just don't know what to do. So we ask you guys to vote and support this bill, and we thank you guys for the opportunity and for listening.
Thank you very much for giving us some insight into Natalia and for being here to testify. Members, any questions? I bet y'all are some amazing parents. Yes, Representative Rose.
I don't have any questions, but I just wanted to thank you all for being here, and also thank my colleague Vicki Goodwin for filing this legislation. It just so happened that this incident happened when we were in session last year, 2 years ago, and I remember seeing it on the news. And then, of course, I was heartbroken about the situation. And then I realized that she was a member of Delta Sigma Theta Sorority Incorporated. So, of course, that took it to another level. And I'm glad to see my sorors here in support of this bill. Just know that I never met your daughter, but I can tell she was definitely a jewel. And I did get to hear visit with some of the sorors from Austin alumni that shared with me about the services and all. But I just wanted to just thank you all because, you know, some people, you know, when things happen, they don't come back and, you know, or they don't know how to, you know, try to go and do something to improve it for the next person. So thank you all for your courage of being here and sharing your story about Natalia. You're welcome.
Thank you. Members, any other questions? All right, thank you. Thank you for being here. All right, Chair calls Tricia Morgan. I'm sorry, Tracy Morgan. Tracy Morgan. I show you as Tracy Morgan with Alpha Kappa chapter of Delta Sigma Theta Sorority, Inc. for the bill. Is that correct?
No, incorporate.
Incorporated. Is that now correct?
That is correct.
That is now correct.
Good afternoon, everyone. To the distinguished members of the Human Services Committee, I am Soror Tracy Morgan, and I serve as the Social Action Chair of the Alpha Kappa chapter of Delta Sigma Theta Sorority Incorporated. I am a college student at Houston-Tillotson University. Thank you for allowing me to speak on the most important bill that we honor Natalia Cox and protect other persons who are threatened with domestic violence. It could have been me. It could have been your sister, daughter, cousin, grandchild. It could have been you 20 years ago as you went through the college halls that you attended. But it should not have been Natalia Cox. I stand before you imploring you to support House Bill 2229, the Natalia Cox Act, a bill that will help protect victims of domestic violence in the future. One of our known facts is that the current Texas Property Code does not allow for domestic violence victims to break their lease without penalties unless they can show documentation like an emergency protective order. But where does one learn that information? This bill is necessary to ensure every victim knows their rights during a time of chaos, a time of fear and confusion, the time when we need it the most. This bill will help create a written notice that can be given to victims of family or domestic violence to assist them in obtaining services that they may need. This bill will require first responders and medical professionals the tools to save lives. Safety, planning, shelter, and protection, rights that have no political lines. The notice would include information on victims' legal rights, such as filing criminal charges, obtaining an emergency protective order, or terminating a lease. All that we're asking is that you help protect every Texan who has the unfortunate encounter with domestic violence. We ask that you vote favorably for House Bill 2229, the Natalia Cox Act. Again, this could have been me, a number of other students, and people who face domestic violence. Will you help save the lives of Texans? Will you protect me? Thank you for allowing me to speak today and for your support on House Bill 2229.
Thank you very much for your testimony. Members, any questions? All right, thank you. Great job. Chair calls Amanda Messino, and then Brenda Warren is on deck. Is Amanda Messino here? Okay, we will show her for the bill, not testifying. Brenda Warren, is Brenda Warren here? All right, if you come on up. I show you as Brenda Warren. I'll wait till you're closer. I show you as Brenda Warren, testifying on behalf of yourself for the bill. Is that correct?
Yes.
All right, go ahead.
Mr. Chair and members, my name is Brenda Warren. I am Natalia Cox's grandmother. Natalia was taken away from us at an early age due to neglected violence. I feel if this law was enforced, would have helped my granddaughter with other options. By passing Natalia Cox, HB 2229 will help another family, grandparents, and family from going through this tragedy. I'm asking each one of you to please pass this law to help and save another family so they don't have to go through this. Thank you.
Thank you very much for your testimony, ma'am. Any questions? All right, thank you very much. Chair calls Michael Orozco. And then Lauren Laverius. I'm sure I did not do that correctly, but on deck. I show you as Michael Orozco, testifying on behalf of yourself. And are you testifying as the constable?
Yes, and I should have, this is my first time doing it, so I should have also mentioned the Justice of the Peace Constables Association. I'll be speaking.
You'll be speaking on their behalf?
Yes.
We need to get that changed then. Can we do that afterwards?
If I do, I do have some brochures that will be helpful in my testimony. If I
Okay, have you handed that to the clerk? And go ahead and get changed, if you'll get that changed.
Yeah, why don't, how do we register?
And the Justice of the Peace.
Yeah, we're going to have you
Texas.
re-register or register with that.
And then we'll call.
And we'll tell you what, if you'll do that, we'll call you up in just a minute.
Sounds good.
If that's all right. Chair calls Lauren, I'm not going to say it right, so Laveris. All right, we'll show her with Texas Council on Family Violence. We'll show her for the bill, not testifying. Chair calls Catherine Saldana. Okay. Come on up. And we show you as Catherine Saldana, sorry, with Safe Alliance.
Correct.
For the bill, is that correct?
Correct.
All right, go ahead and testify, please.
Good afternoon. My name is Catherine Saldana. I am a legal advocate with the organization Safe Alliance. I am here today on behalf of SAFE in support of House Bill 2229, also known as the Natalia Cox Act. The acceptance of this bill is essential in assisting victims of family violence with information about community resources. Currently, responsibility of disseminating information relating to family violence is limited. This bill hopes to expand dissemination to include relevant professionals and community members who may interact with victims of family violence. The acceptance of this bill is essential for assisting survivors with receiving information. Having local stakeholders providing community resources on family violence and victim services is a crucial first step in safety planning. For survivors, having information available can help victims remain safe and decreases the likelihood of future victimization. With wider dissemination of this information, community stakeholders, victims of family violence will be able to connect with resources sooner and provides them with an opportunity to ensure their emotional and physical safety. We also know that best practice shows that prevention for family violence is community education. So on behalf of SAFE, we would like to thank you for your consideration and hopeful approval of this bill.
Okay, thank you. Members, any questions? All right, thank you very much. We ready for the constable? Tell you what, let's go, we're going to go with chair calls Andrea Fresh. Oh, okay. Just make sure it's, okay, Andrea, if you'll hold tight, and then Constable, we'll go ahead and, okay, there we go. Chair calls Michael, or we show you as Michael Orozco, representing yourself, representing the Justice of the Peace and Constables Association of Texas.
Yes, that's correct.
Okay, for the bill.
Yes.
Okay.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. My name is Michael Orozco. I'm one of the 5 elected constables, and I currently represent the Office of Dallas County Constable's Office Precinct Number 5. I'm also speaking on behalf and in favor of the Justice of the Peace Constable Associations of Texas. So why am I here? Back in 2009, I met a young woman in a similar situation. And because of my over 25 years experience in the constable's office, we are unique because we enforce both civil and criminal law. So I knew about some of the remedies that this woman came to me for some help. I was able to successfully provide her those remedies. She was able to resolve her tenant-landlord relationship and ultimately had an avenue for escape. So I said to myself, I've never seen these remedies ever printed on any domestic violence flyer. So I said, hey, why don't we make this state mandated? So in 2021, I reached out to Representative Carl Sherman, who in fact filed a bill in behalf of my ideas about putting some of these remedies from the Texas Property Code in and make it state mandated. Unfortunately, it made it to committee and never got put on the agenda. And I called repeatedly, sending emails, just begging to have the opportunity to talk and argue for that bill. And that was in 2021, the last legislative session. So now we're here today. And it didn't stop me. I said, this is such a great idea. Let's just go ahead and start at the local level. So currently my precinct overlaps probably like 90% of the city of Dallas. And then, of course, we're a Dallas County entity. So I pitched my idea to the city of Dallas, the Dallas Police Department, and the Dallas County Sheriff's Department. They loved it. They agreed that this is much-needed information that needs to be disseminated because, frankly, no one knows about these remedies. And it's of utmost importance to get this information disseminated. It was really hard today. It was my first time meeting the family of Natalia Cox and showing us this brochure that they could have provided answers to their daughter that was in this situation. So I'm here in support. I've obviously proven that this is currently working on the local level. Dallas County is the second largest county in the state of Texas. If it's good enough for Dallas County, it's good enough for the state of Texas. And in closing, I just want to say whether you're Democrat, Republican, Tea Party, Green Party, Libertarian, each and every one of us on the membership, and everyone in this room, we share one thing in common. We just want good government. The Natalia Cox Act is good government. This is good government. Please help ensure that this legislation passes and it's implemented into law one day. Thank you so much.
Thank you, Representative Noble.
We were just admiring your brochure. It's really well done.
Oh, yeah.
Including the phone numbers on there and the information. Just really impressed with that. How do you get that out to the people? Do the police carry it? Just the constables? Who carries this with them?
So the Dallas Police Department. That was the whole purpose because they're the ones that are out there, responding to calls for service. The good news is that this helps in a support role. In our larger municipalities, it's very common to provide what's called a civil standby to help collect personal belongings. The problem is there's nothing in statute that says you can do a civil standby. But there's a right way. They can do the writ of retrieval. The responding officer can disseminate this information to them. And in my research with the city of Dallas, they told me that on occasion, when they do provide a complimentary civil standby, it can sometimes tie up from anywhere from 2 to 8 officers. This allows them, by giving them the information, they can move on and respond to more calls for service.
So you do it both. Do you do it in writing? Do you also have it on a website?
I believe the city of Dallas is. We're right now in changing some of our issues on Dallas County, but we do have this in the JP courts and so forth. But the good news is, because of this, we have seen a huge filing and writ of retrievals in our courts. So it is working.
Great, thank you.
I'm just curious from an implementation standpoint, like because this is great.
Yes.
If you do it at the state level, is it going to be, do you see it being the same everywhere? Because an 800 number, a 512 number is not really, I wouldn't think, what we need out in Wichita Falls or Seymour, Texas, or that kind of stuff. So do you see the state putting together a template that is then used by the locals? What do you see the best interplay between those?
That's a great question, Mr. Chair. The good news is the language that was created on this brochure one of our assistant civil DAs, and he collaborated with one of the city attorneys from the city of Dallas, and they came up with this language. The good news is it's purely informational, and it's not legal advice. And so to answer your question, I think if some type of similar language is added like this, absolutely. If we come up with a generic language that's purely, like I said, informational, not legal advice, it will work.
Yeah, you almost feel like it's a state template, but local massaging, I guess, because you don't want. I would hate for us to be calling 800 numbers or 512s, because that is not the way law enforcement works.
Now,
but
this was my idea to add my name in our Justice of the Peace, which we gladly do.
Right.
I think that should be something that would be up to the local officials or local agencies if they choose to add who's in the constable's office at that present time, or any of the JPs there locally. And the good news is that I know we aren't limited to a precinct, but I intend to help out the other constables in Dallas County, come up with this plan, and hopefully implement it at the local level there as well with their respective cities.
Thank you very much. Members, any other questions? All right, Vice Chair Rose.
Thank you, Mr. Chairman. I just wanted to know, where can I get some of these brochures? Because, my office is, have you seen my office before, right there on Lancaster and Keith? So,
No, I've never had the pleasure of attending, but I'm familiar with
You're invited right now.
but you know where Lancaster and Keith is,
Oh,
right?
absolutely. That's what I said. I'm
next to
familiar with it.
Yeah, okay. Tell me something. But, so you said, is this the constable's office or it's a collaboration?
It's a
and I
collaboration with the constable's office, because they themselves are a different law enforcement agency.
Right.
I felt it was of utmost importance to get, since they're the ones that deal with more people, more calls for service, that this information would be added so they can have their officers disseminate this flyer to.
Okay, so I can get some from Chief Garcia, because unfortunately, over in 75241, we have high incidence of
Absolutely.
domestic violence, and I really would like to distribute these in the district, so,
We'll get them to you ASAP.
okay, thank you. That's what I needed to
Thank you
hear.
for your testimony. Chair calls Andrea Fresh. And then Brittany Henry is on deck, and I show those are the last people to testify on the bill. Ma'am, we show you as Andrea Fresh, am I saying that right?
Andrea, yes.
And I'm sorry, Andrea Fresh.
Yes.
Self for the bill, is that correct?
Yes.
All right.
Good afternoon to all the committee chairs, chair president, chair vice president. I was a friend, am a friend of Natalia Cox. We entered into the great organization of Delta Sigma Theta Sorority Incorporated together. And sadly, our friendship was cut short. Sorry.
No, it's all right.
Natalia met this person for a brief period of time, and things escalated very quickly. This is all public information that I've gathered, and this is public information within the affidavit written up for Natalia Cox's murder. So I believe it was on March 25th of 2021, Natalia called the police with a terroristic threat. There was body cam footage of the person trying to reach Natalia. She was visibly, in the affidavit, this is all public information, she was visibly shaken, visibly scared. She asked the person to not contact them. She blocked the number. And she immediately left her apartment, and she luckily had a place of refuge where she could stay safe for the night. And while this is in honor of Natalia Cox, she was not the only woman in that apartment. Fortunately, we are only here today honoring one person's death. Luckily, not two, because in this case, there could have been two. So I think it's important that we acknowledge that we were fortunate to escape this situation with only having to grieve the loss of one person. But both of those people went to the police department. They called the police. They filed a police report. They got a police report number. But that wasn't enough. They weren't given any direction to go otherwise. And personally, as a person, besides the other person who lived with her, the only brochure we received was after she was murdered to help handle our grief. There was no resources, no information that was given to us on how we can help. I'm currently still a college student. She was a college student. We had no idea how to. I'm sorry. We had no idea how to navigate the system. We tried our best to do the right thing. And as previously mentioned, Natalia was exceptionally smart. So she knew a lot of things that a lot of people didn't notice. On KVUE News, it stated that some victims of domestic violence are given a pink pamphlet based on certain specific circumstances that fall under domestic violence. She experienced a terroristic threat with somebody coming to her home property with a weapon, threatening her life. Her life was in immediate danger at that moment. I'm not exactly sure what would constitute somebody providing resources to help themselves when they're in immediate danger. However, it wasn't enough for her to receive that information. They said that what she went through wasn't enough to receive resources. At the bare minimum, what she could have been given was a resource. At the very bare minimum, however, it was not provided. Also during this time, it was COVID-19, so a lot of times, a lot of things were backed up, and it put a hold on the process. That affidavit didn't reach the prosecutor's office until after she was murdered. So her even getting that resources was taking way too long. I feel there should be something in place where you can provide somebody resources before having to go through the courts, before having to get approved by a prosecutor, because that takes time, regardless of COVID-19. So for me, this bill would provide the bare minimum to victims, not just of domestic violence, because it's, as we can see, you can be here one day and be gone the next. I guess I'm not really understanding why there has to be certain specifications met of danger for somebody to be provided resources. And I have messages that I'm reading right now, and this is from the person Natalia was with, because she was with someone else trying to do the right thing.
And I'm sorry, I'm trying to think. We just can't have testimony from another person. I guess that's.
I'm not that person.
Okay, right.
I'm not that person. I'm not related. Like, they're my friends.
Right. Yeah. I know nobody's going to call a point of order on the bill. I just. Yeah, go ahead.
Okay.
Go ahead.
So as mentioned before, they were trying to reach they were trying to go to the police. They contacted the police. The police has footage of them being visibly scared, of the person trying to contact them in real time, not stopping, with the police present.
Okay.
And the police didn't think to say, here's something that you can do. here's how you can help yourself, they really kind of just took all the information down and left them to figure it out themselves and continue down the path that they were on, which was unfortunately for one person death.
Yeah. Okay.
And I don't know if is this timed? Are you limited to time?
Yes.
Okay.
We-
Okay.
We blew by that a long time ago. I was trying to. but
So again, all of this is public information, and I personally learned this information for the simple thing of what's known as a pink pamphlet. I had no idea that victims of domestic violence, do you guys know what a pink pamphlet is? Okay. I had no idea what that was until I read the news article, which came out after she had passed away. So again, passing this House bill will provide Texas citizens, Texas women, with the resources before it even gets too far. Because there are people who try to reach out to the people that are supposed to protect and serve us and provide us with resources. And we can't come up to the committee and say, I need help, because in a matter of days, your life can be taken away. So I just want to be for this bill because, like I said, the only resources that I learned about, that I was able to dig into, do my research on, was after the fact. Had I had known that there were all these resources, Texas code law, how you can break your lease, different things like that. I learned all of this after the fact. We need something that will be able to be a service to someone in real time. There's nothing that, and without the specifications, I feel like it's not that hard. This officer just came and gave you all a brochure and you loved it, you looked at it. Just like that, you could find resources. Passing this House bill would do that all over the state of Texas, not just in this room. So,
okay. Thank you very much. Members, any questions?
I do.
Ma'am?
Ms. French.
I thought I was wasting y'all's time. I was about to say, let me move away from this chair.
You're definitely
Rose.
not. Thank you, Mr.
Vice Chair
Chairman.
Rose.
You're definitely not wasting our time. And so you had stated that you had some comments from the person who was with Natalia at that time. Could you share those comments with us at this time?
Yes, so I'm sorry, I'm young, I'm new school, so I have my phone up here.
You're good.
You're doing a great job.
But she said, we're going to the police station. They're not doing in-person reports, so we have to find one of the smaller precincts in our area. After that, I said, this is after they already had the interaction with the police where they could see the person trying to constantly contact Natalia. They have footage of her blocking the person's number. That person's still trying to get in contact with Natalia, telling them, meet me here, meet me here. Not leaving them alone, saying, oh, I thought we had something going, so that's why I'm upset. This is all in the arrest affidavit that you can find, public records. So that day we were keeping in contact, and they had let me know they were going to the police, and they received a police report. They had to file one, actually. They weren't able to do one in person. Though an officer did respond to them and meet them in person, they still had to go out and try to file the report. Because of when the incident occurred, it was hard because COVID was around, which is still around. But I responded to her, pardon my French, I said, F the police. They don't see this as an emergency. I wish they did better. She said, literally, we just talked to some of our other friends who are in this room, and they said the same thing. We just wish they did better in identifying emergencies. I feel like if they would have not gone by this strict specifications of what falls under the umbrella of domestic violence, it was a terroristic threat, which requires the gun be removed from that person and that person be like found immediately. But that person was not. And they didn't see that this was an emergency for Natalia. Even though they have body cam footage of her visibly shaking, they still said that's not enough. And though this is not about her apartment complex, this was the first step that would have enabled her to break her lease, because under certain circumstances of domestic violence is when you receive that pink pamphlet. And then once you receive that pink pamphlet and you have a protective order, then you can break your lease. But if I'm being completely honest, I did not know that at the time. She did not know that at the time. That is the importance. We were not seen as, this incident was not seen as an emergency. I don't understand that when somebody's telling you that they're gonna shoot the door open. This wasn't it didn't happen. She had a threat. There was a threat that happened, that occurred prior to her tragic death. And why isn't a threat enough to receive resources? We're not asking for you to stop the world, physically go in and help her move and relocate. Just simple resources. The only resource we knew was 911.
Okay.
And that's the only resource we left with. This information is all coming to us after we've lost someone.
Okay.
So what we're asking is for you to find favor in passing this House bill to provide someone with the resources in real time, because none of this information is provided in real time.
Thank you very much.
Thank you.
Members, any other questions? All right, thank you for your testimony. Chair calls Brittany Henry, and I show nobody else wishing to testify. We've got you listed as Brittany Henry, testifying for self for the bill. Is that correct?
Yes, sir, that's correct.
Okay, thank you.
Greetings, everybody. I am Brittany Henry. I am a college senior right now. I met Natalia my freshman year at Houston-Tillotson University. When I met her, I had a lot of things going on, and Natalia was just one of those people that you could walk up to and talk to, and she just makes you feel so much better just by her smile. Her smile brightened the whole entire room up. So leading up to the event that had happened with Natalia, there was threats going on. There were threats sent to Natalia's phone saying that this person was going to harm her. This person had started contacting her from different numbers, a ton of different numbers, harassing her to the point at sometimes she would have to turn her phone off. Excuse me. During those times, myself and her line sisters we all tried our hardest to make sure that she was safe, as well as her roommate. We tried to make sure that she was safe. We tried to make sure that she had places to sleep while she was trying to figure out the apartment stuff. We tried to just make sure that she was protected. I feel like the system failed Natalia because, as Andrea stated, there were plenty of threats being given to her, and it shouldn't have been us, her friends that are in our early 20s, trying to figure out what can we do, what more can we do. We shouldn't have to figure that out. That should have been done by the police, and all of this should not even be happening because Natalia should have been protected in that moment. Natalia did not receive any proper information on how to get away from the situation. Natalia was very smart, so she started looking stuff up and she started to figure out what she needed to do. But as a 21-year-old, you shouldn't have to do that. You have the government in place to help you. She was a 21-year-old student. She was focusing on school. She was focusing on her sorority. It was a list of things that Natalia did, and this just should not have happened because she should have been protected by her government. She shouldn't have had to rely on herself or her roommate or me or her line sisters or any of her other friends. So I hope that this bill could be passed because since this year I've had a child. My son is the joy of my life. So I could not imagine losing my son to something that could be prevented. I shouldn't have to be up here talking about this, Mr. and Mrs. Cox shouldn't have to be up here talking about this. None of this should be happening. But since all this is happening, I just hope that the bill is passed, because it could have easily been me. It could have easily been any of her line sisters, any of her friends. It could be any of y'all's children. And I feel that this bill will help protect women in Texas, because so many of us go through domestic situations and we don't know what to do. I didn't even know what a pink pamphlet was until after the situation happened. And I felt like that's something that Natalia should have known, because although it was in times of COVID-19 and all of that, that does not excuse the right to protect a citizen, especially a 21-year-old that has already did all of the precautions that she knew to do, and no other precautions or nothing, no other information is being given to her. So I hope that this bill is passed, and I hope that we can just do better with protecting our women in Texas, as well as, I guess, everybody in Texas.
We might as well get everybody. Members, any other questions? All right, thank you very much.
Thank y'all so much.
At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 2229? Seeing none, public testimony is closed, and the chair recognizes Representative Goodwin to close on her bill.
Thank you, Chairman. I did want to say HHSC already collects a lot of this data. You mentioned what's right for one part of Texas may not be right for another part. So the bill does give latitude to HHSC to work with the organizations, victim service organizations. They've got a compilation of organizations on a website right now, but they have the latitude to make it work for a statewide venue. We feel like this is so important that we don't get it right just for Austin, or we don't get it right just for Dallas, but we get it right for the entire state to help these young people know what resources are out there, or not young people. I mean, like she said, all of Texas. So with that, I close. Thank you.
All right, thank you. The committee substitute is withdrawn, and if there's no objection, the bill will be left pending. Is there objection? The chair hears none, and House Bill 2229 is left pending. The chair lays out House Bill 2572 and recognizes Representative Lujan to explain his bill. Go ahead. Actually, go ahead. Go ahead. Go ahead. You can wait.
All right.
Man, you know how to clear a room.
Yeah, I do. But thank you, Chairman Frank, and members of the committee. I'm here to talk about 2572. The Department of Family and Protective Services maintains the Child Abuse and Neglect Central Registry, which is used to identify offenders for abuse or neglect of a child. One function of this registry is to conduct background checks to determine if a person has any alleged designated or sustained abuse or neglect findings that make the person ineligible to be present or work with children. So this bill has basically two parts to it. The first one is for the Texas Juvenile Justice Department. Currently, the Texas Juvenile Justice Department is not required to report to this registry. This bill, HB 2572, seeks to include the Texas Juvenile Justice Department, TJJD, to those required to report to this registry. That's the first thing. The second thing it does, it aims to close a loophole in reporting by including the Health and Human Services Commission to the Texas Family Code. This will ensure that the statute is consistent with the rule and avoid any future confusion if there are rule changes. So currently, the Health and Human Services, they do report to the registry because there's an administrative reason to do that, but it's not in the Texas Family Code, and it's just kind of codified and make it kind of permanent. It is our duty as leaders to protect Texas children and ensure that no person investigated and convicted of abuse or neglect of a child would be eligible to qualify to work with children or at a child care facility in Texas. I'm happy to answer any questions you may have and respectfully reserve the right to close.
Thank you, Representative Lujan. Members, any questions? I do think one of the, to me, this is a fascinating and important topic in terms of who gets on registry, at what point, that kind of stuff, because you have this, you know, when somebody gets convicted, how much is enough information to have on there where you're not putting, you know, any, what do you call it when you, any allegation on there, but yet making sure that anytime there, it gets to a certain point of proving that that information is available so that we try to protect people. It's just, it's such a difficult balance, and we haven't gotten it all smoothed out across the many agencies. And so appreciate you stepping up on that. Members, any other questions? That wasn't a question, that was more of a comment, but would you like your right to close? You do have 2 witnesses.
Yes, sir.
Okay, we will have it. Chair calls Jennifer Allman, the Texas Catholic Conference of Bishops, testifying for the bill. Did I get all that right, Ms. Allman? All right, Jennifer. All right.
My name is Jennifer Allman, and I'm the Executive Director of the Texas Catholic Conference of Bishops, and we're testifying in support of the bill. We appreciate that Representative Lujan has brought this forward. There is somewhat of a Swiss cheese of background checks systems.
That is well said. It's like, yeah.
And we see that more than most others because we operate in so many different sectors of the community. We have ministries in criminal justice, we have ministries in childcare, we have ministries in private schools, and we have foster care ministries. And so what we find is we check one registry and nothing comes up, but if that person were to apply in a different one of our ministries, something would come up. And that's a problem in terms of child protection. I think there's going to be a lot of legislation filed on this topic this session and lots of different ways of doing it. So our plan is to testify each time and say, good job, thanks for trying something. All of it improves a little bit. And so we appreciate this bill. The one recommendation we would have if there's going to be a sub, if it's going to change at any point, would be to add the do not hire registry from the TEA into the agencies that report into the central registry, because that's where teachers who have a finding of fact through an ALJ, so there's been some due process that takes place, that's where they're reported. And it is public facing, so anyone can go to the do not hire registry and see names. The problem is there's not birth dates and social security numbers to protect privacy, but there's a lot of people who have the same name in Texas, and I certainly don't want someone to be pinged because they look at that public-facing website and their name is the same as someone who has abused a child. And so I think it's really important that we work on that, and in the central registry, the providers who have access to that registry can see those more identifying pieces of information to make sure we're preventing the wrong people from working with children, but not holding it against someone who happens to just have the same name as someone who's harmed a child. So as is, the bill does great things. That would be one more little thing to make it even better. And we thank the committee for looking at this important topic.
Okay, thank you. Members, any other questions? Thank you very much, and thank you for working on this issue. Chair calls Chris Willoon, Texas Appleseed, showing for the bill, and I'm sure I didn't get that last name correct. Once you
Pretty close. Good afternoon, Mr. Chairman. My name is Chris Willen, representing Texas Appleseed in support of House Bill 2572.
Thank you.
We thank Representative Lujan for this important legislation. As you've heard, this bill adds the Texas Department of Juvenile Justice and codifies HHSC's current participation in the Child Abuse and Neglect Central Registry, which is operated by DFPS. Doing so closes a loophole wherein an individual with a substantiated allegation of child abuse or neglect from TJJD's Office of Inspector General could gain employment in a facility licensed by HHSC, potentially exposing children to unnecessary risk of abuse, neglect, or exploitation. While DFPS and HHSC both require background checks for their staff members at facilities under their oversight, these background checks will not capture incidents of abuse and neglect in which there was a substantiated allegation made through the TJJD Office of Inspector General administrative process, but for which no criminal charges were filed. House Bill 2572 addresses this issue by ensuring those incidents are contained within the registry. Finally, after reviewing the fiscal note for this bill, I was surprised to see that TJJD currently is not giving people full due process via a SOA hearing when there is a substantiated allegation of abuse or neglect, which is a major concern for this committee. Based on the fiscal note, fortunately, it seems that the agency seems to believe that this bill would remedy that issue. So apparently this is 2 for 1 here. We're going to better protect children in the state's care and the due process rights of persons accused of child abuse, neglect, or exploitation within TJJD, and that's all the more reason to move it forward. Thank you all for your time and Representative Lujan for this proposal, and we urge the committee's favorable consideration.
Okay, thank you. Members, are there any questions? Okay, at this time, there are no witnesses signed up to testify. Is there anyone else here who wishes to testify on, for, or against House Bill 2572? Seeing none, public testimony is closed, and the chair recognizes Representative Lujan to close. You had a question? Oh, okay, all right. We'd like to call up the resource witness.
Who is a resource witness?
We have DFPS and HHS.
It looks like about do we have anybody from TJJD?
Yes.
TJ,
Call
okay.
Preston.
Good afternoon, members. I'm Preston Stroifert with
Okay,
TJJD,
hold up,
Director of
Hold
Stakeholder
up,
Relations.
hold up. The chair calls Preston Strufert with Texas Justice Department. Go ahead, sir.
Yes, ma'am. So I'm the Director of Stakeholder Relations with Juvenile Justice Department.
Thank you for being here. Appreciate that. I'm a little concerned that it takes 3 full-time employees to implement something that we should be doing as a matter of course to protect the term is pass the trash, to protect our children within our system from someone that's already proven to not be trustworthy. Why does that take quite a huge fiscal note?
So here's some background on our registry. We certify folks that work in counties, all of their probation chiefs, officers, supervising officers, they get a certification from us. If you're an employee of TJJD, you're under the same code of conduct, but you're just an employee. We don't certify you. So if you would be fired by TJJD, you're fired, you're given an employee grievance procedure. It's a different track. And we only recently, in our registry that would show you as revoked. There's nothing to revoke for a TJJD employee. Alternatively, if you're a county employee and your certification is revoked or suspended, you're given that due process option to go to SOA, the State Office of Administrative Hearings, and have that level of due process. These are effectively kind of the same thing. So what we did in our registry is we said if you're fired, we still need to note that your conduct was on the same par as being revocable had you had a certification, but there was nothing to revoke. And that's the same for even folks who work in the counties. They have 180 days to complete all of their requirements to get certified. So where this status of being ineligible for certification came from was folks in counties that commit conduct before their 180 days or before they're certified. We still wanted to note in our registry that they had committed this conduct, but there was, again, nothing to revoke. They're kind of on a temporary basis. They're waiting to get their certification, right? So we have in our registry, as of recently, TJJD employees, similar deal. They have nothing to revoke, but we're going to make you ineligible. And really, this is an internal database that we maintain so that our probation departments and TJJD, our facilities, know that these folks have committed some kind of act, abuse, neglect, exploitation, or something against our code of conduct that would have had them revoked. So what the fiscal note does, this is all background just to let you know that we would be looking for 3 attorneys because if you are going to put them on the DFPS Central Registry, our general counsel's office felt like this is a whole new level that would require the due process of going to SOA, whereas this group of folks were previously not going to SOA. And SOA costs money as well. You have to pay them, and I think you almost kind of prepay SOA. They anticipate your need, and you as an agency pay them out. That's kind of my broad understanding of how SOA works. So a lot of the fiscal note is not all TJJD, but a good chunk of it is. And we have also provided the author. We approached their office yesterday, so it's still cooking. But we have language that might make us not have to go to SOA for just sharing this in batches. So on our end, if this language was agreeable and it's still, again, cooking, we would, I think, have no fiscal note on TJJD's end. Now, that being said, if y'all are interested in TJJD providing SOA to this group who previously wasn't getting it, we would need to just have more legal resources and pay SOA more for their hearings to do that.
I don't know about, can't speak for the other members of this committee, but to me, if somebody gets fired because they're not showing up to work, I don't care about that.
Sure.
But if we have someone that's abused or neglected a child under our watch, and we're not letting other parts of government know that, and frankly, the public know that, and they hire them to work in a daycare or somewhere else, that's egregious, and that's something we need to fix.
It's information that we would share. I know with the recent situation last year with the refuge, for instance,
Yes.
This person was a former TJJD employee. If someone would have called TJJD, we could have shared that.
But they didn't know probably to call you.
And it's also
so.
possible that folks are not going to put on their resume, I worked at a place that fired me for abuse and neglect. So these kinds of bills are helpful, and we want to help. But like I said, it depends how you want to do it. And if you want folks who are fired and then made on this ineligible status to go to the State Office of Administrative Hearings, and again, I think with the language that we would be suggesting in the alternative would be sort of batching this data, providing it to DFPS, and then they can kind of do with it what they will. And, they have their own process to get off of the registry. I was just in the Senate last week hearing about it. So if you get popped on the registry, then you can go through SOA that way. So on TJJD's end, all we've really done is shared this information. I also just wanted to point out that in the chapter that defines abuse, neglect, exploitation, there is the very first section is definitions of abuse, neglect, exploitation, but it contemplates what would happen to somebody in foster care. And so if you go a few sections down, section 261-405 is a whole new set of abuse, neglect, exploitation, and that would be what our Inspector General investigates in our facilities and other facilities that hold juvenile justice youth, so county facilities as well, or county placements. So that being said, part of the reason this has not been shared is because these two databases don't really match up. And again, our registry is simply, it's internal but shared with counties because we certify them, and it is our kind of do not hire because of that. And I say it's internal, but it's shareable if you just call and ask, right? But if we want to human-proof the situation, I suppose, then we're trying to get them on the DFPS registry.
Okay, thank you.
Yeah.
Thank you. Members, any other questions? And would you, who we got? Okay, very good. Members, any other questions? All right, thank you. No one else? Okay. At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 2572? Seeing none, public testimony is closed, and the chair recognizes Representative Lujan to close on HB 2572.
Yes, sir. Chair and committee members, thank you. Representative, that was a good line of questioning, because that's the main intent of this, to put all of this in a registry so that people can check and not have to go to different places to get to one. I was notified yesterday of the fiscal note of $2 million, but I understand since then it's gone down. I still don't agree with that, but we'll be working through those things, and we'll be getting back. But thank you so much. I appreciate it.
All right, thank you. If there's no objection, House Bill 2572 will be left pending. Is there objection? The chair hears none, and House Bill 2572 is left pending without objection. All right. What's that? Yeah. Okay. The chair lays out House Bill 2641 and recognizes Representative Johnson to explain her bill. And just so you know, you're not unpopular. We do have people in other committee hearings, but they're.
I completely understand. Yeah. We are all chasing our tail today and in multiple places, but I'm grateful to see you all and excited to be able to lay out this bill and what it can accomplish if we could get this done. House Bill 2641, rapid whole genome sequencing, is a bill that will address a much-needed population in Texas. What this will do is work where individuals, and mostly children, have rare diseases, oftentimes going 5 to 7 years between specialists before getting an appropriate diagnosis. The frustration, the unnecessary burden, the disease progression, and the cost to the state Medicaid program is high. What this bill would do is allow a pathway for reimbursement for these rapid whole genome sequencing, which again will ultimately reduce costs. I can also tell you that in my family, we have experienced this. A child around 11 months that began having seizures and for years went undiagnosed with the proper genetic disorder that he had. Before he began having seizures, he would say things like, let's go, to get in the car. Through the course of that time period, improper medication that we in fact figured out was one of the worst things that could be given with his very rare genetic disease. Today, he is completely nonverbal. And so I have seen the impact that it can have on families to not get that proper diagnosis. And there is nothing more grueling on a parent than seeing your child suffer, them not be able to communicate with you, and not be able to get care. We do know that setting this parameter would help many of those families and many Texans. I will say, I don't know that it will help as many Texans as is currently showing in the fiscal note, just so you know. We do think that there is an error in that, and we have asked to redefine our utilization population to address the very sizable fiscal note. Representative Noble, I saw that. And so just so you know, we do expect to have a committee substitute, one, to increase the net so that more folks here in Texas can perform these services, and two, to address the fiscal note. So I was hopeful we'd get back by now. We haven't. I'll let you know as soon as we do get it, but I do understand the eyebrow raise, and hopefully that's not what we're looking at. Chairman, thank you very much.
Sure.
We do have witness, and I would ask the time to reserve to close.
Just a quick question. Do you know is this covered under typical commercial? Is it, is it 1%, 100%? Everybody covers it or nobody covers it? Do you know?
I don't know the answer. Hopefully one of our witnesses can answer that question.
Okay, thank you. Members, any other questions?
Thank you so much.
All right, the chair calls Danielle Zabilski. And we show you as Danielle Zabilski, testifying for self for the bill.
Yes, good
Is that
afternoon.
right? Is that correct?
Yes,
Okay.
you did. Better than the guy who married us. He practiced and butchered it.
It's not that hard. Zabilski.
I want to thank you for giving me the time to let me speak to you today. And Mrs. Johnson did such a good job in a lot of what I was going to say, so I'm going to kind of cut right to the chase. As stated, I'm Danielle Zabilski, and I live here in Austin, Texas, and I'm the mother of 2 young children with a rare disease. The journey to get answers was grueling. I guess I'll start with the fact that my son was born 32 weeks preemie, and he spent a month in the NICU. And that at that moment in time, we thought it was just the fact that he was preemie. He was having difficulty thriving, growing, breathing. He was missing a heart valve, so his heart wasn't regulating properly. But over the course of a long and grueling month, he was sent home with us, and we were told that he was a healthy little boy, and this was a one-time incident, and we didn't have to worry about anything. Life from here on out was going to be great. But as his first year went on, he didn't meet milestones more than the adjusted 2 months that we were expecting. He was delayed to crawl, delayed to walk. But again, we were kind of given routes of therapy and just told, keep on, he's going to catch up, he's going to catch up. Around 12 months of age, we started having asthmatic episodes and spent many days going to Dell Children's Hospital trying to get an understanding of what was going on with him. Around 15 or 16 months old, he began to lose his baby teeth. As soon as they would come in, they fell out. The dentists that we went to here in Austin told us that possibly he fell down the stairs and, we missed it. And as a mom that was around him all the time, I tried to tell them, no, this wasn't what's going on. Something else is going on. But we were dismissed over and over again and told he was just fine. After he had lost 6 teeth and many hours of researching myself online, I came across what I thought was maybe his diagnosis. It's a rare disease called hypophosphatasia. I'm sure you probably have never heard of it, and none of the doctors or dentists or specialists we went to had heard of it either. I found out that the St. Louis Shriners Children's Hospital was one of the best places in the world to treat hypophosphatasia, so I called Dr. White there, and after a phone call over my lunch break, confirmed that, in fact, I probably was right with my diagnosis, and he suggested that we come to St. Louis and evaluate what was going on with our baby boy. So we took a week off of work, my husband and I, and made the trek thousands of miles. Well, what is it, maybe 600, 800 miles to St. Louis. And we received his diagnosis there. Not a genetic diagnosis, just a clinical diagnosis. At the time, Shriners didn't have the funding either to do the genetic test. And so it was kind of the best guess for, the renowned specialist to diagnose him. He thought it was a milder form of hypophosphatasia and that we could follow up with him a year from then. So fast forward 4 years later, my husband and I decided to pay out of pocket to get genetic tests done, thousands of dollars. It was not covered for insurance for my son or for my husband and I. So we paid and we sought out genetic counseling, and we're told that if we had another child, it would have a 1 in 4 chance of having the same disease. But that genetic counselor in the Shriners Research Center had told us it should still be a mild form. So I got pregnant and had a beautiful baby girl. And she spent herself a little over a week in the NICU, and we decided it'd be best then to pay again out of pocket thousands of dollars to get her genetic test done to have that answer, because going through the unknowns is a parent's worst nightmare. We found out that she too had the genetic disorder, and we're told that we could follow up with Shriners Children's Hospital and that hopefully our case would prove mild. She, around 6 months old, I started noticing her skull was misshaped, and I questioned it over and over again, and pediatricians here told me that maybe she spent too much time laying on her head. Let's put her in a helmet. It's going to correct it. Even though we had her diagnosis, it was still mistreated. I had to fight to get a skull x-ray on her, and we found out that she had a rare side effect from hypophosphatasia, craniosynostosis, and her sutures had closed prematurely. She had Chiari malformation, which was pressure on her spine. And if I would not have had her diagnosis and I wouldn't have had that mother's gut instinct to keep questioning, putting her in that helmet, causing excess pressure on her skull, would have probably caused severe brain injury. It would have affected her sight. And now I can say, we went through skull surgery at 11 months old up in Dallas, Texas, and she's now a beautiful 9-year-old, and because of treatment from a drug that has been miraculous in both of them, you wouldn't look at them, and besides when they had missing teeth all the time, you would never know that they had this disease. But there's so many patients and parents and babies who go through that journey, and they either have to pay out of pocket like we did or travel thousands of miles like we did and not get the right treatment early on. And so I urge your support in this, because I know that especially with these rare diseases, having access to early treatment and early specialists is life-altering.
Okay, thank you. Members, any questions? Yes, Representative Noble.
I know it's been several years since you've had this done. What does it run to have one child tested?
I remember it, I mean, when we had my son, my husband and I are out of pocket, and we have great insurance. I'm a teacher.
So the
and
teacher, so the insurance did pay part of it,
It
or
did
not?
pay part of it.
Okay.
I want to say we had to meet our family max deductible, so maybe $4,000 in order to have it done.
Okay, thank you.
Thank you, members. Any other questions? Okay, thank you very much for your testimony. I see nobody else wishing to testify, or there's nobody else signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 2641? Seeing none, public testimony is closed, and the chair recognizes Representative Johnson to close on House Bill 2641.
Thank you again very much, Chairman Frank. The application of this bill would be for Medicaid. It does look like many plans will cover it, and I'm going to supplement and get you all the information to answer that question. This would be for a population under 1 year old when they present with certain complex and acute illnesses of unknown origin. It also looks like cost of this test is about $5,000. By comparison, it's $6,000 to have a child in the ICU just for 1 day. And so, again, while this may be a cost, we anticipate that it will balance out excessive cost in improper diagnosis, which is good for the child, family, and their parents in the state of Texas. So thank you very much. I'll close and ask your favorable consideration for this bill.
Thank you. If there's no objection, House Bill 2641 will be left pending. Is there objection? The chair hears none, and House Bill 2641 is left pending without objection. Yeah, I'm gonna do campus since Rose isn't here. Liz, you ready? You good? Okay, the chair lays out House Bill 1290 and recognizes Representative Campos to explain her bill.
Good afternoon, Chairman Frank and members of this committee. Thank you for the opportunity to lay out House Bill 1290 related to federal stimulus payments and nursing home patients. Last session, HB 2090 passed unanimously in our Human Services Committee, but ran out of time in the House. The bill would explicitly prohibit and significantly punish long-term care facilities for confiscating federal stimulus checks meant for their patients on Medicaid. The stimulus checks are considered tax credits per the CARES Act and don't count as resources for federal programs like Medicaid. Therefore, the government cannot claim them, and neither can the nursing homes. It is common practice for nursing home facilities to serve as financial stewards for their residents, especially in the case of Medicaid patients. And it is my understanding that the great majority of these facilities do so with the utmost transparency. Unfortunately, there are some bad actors that prey on vulnerable seniors for financial gain. During the COVID pandemic, members of the Texas Silver-Haired Legislature, the Texas Ombudsman for Elderly, and the AARP raised concerns that stimulus checks meant for seniors were temporarily withheld and/or illegally confiscated by their nursing home facility. HB 1290 would introduce a state-level deterrent to complement any federal penalties for confiscating stimulus checks. A long-term facility that engages in such activity would be subject to an administrative penalty of $25,000 per violation, and each day that the facility fails to return confiscated money to the resident and would be considered a separate violation. I am open for questions and reserve the right to close.
And we'll have it. Members, any questions? Pretty straightforward. There are a number of people that shared their opinions and registered, but nobody showing to testify. So at this time, there's no other witnesses signed up to testify. Is there anyone else who wants to, or is anyone who wants to testify on, for, or against House Bill 1290? Seeing none, public testimony is closed, and the chair recognizes Representative Campos to close on House Bill 1290.
Thank you, Chairman. House Bill 1290 would deter bad actors that prey on vulnerable seniors for financial gain. And with that, I again respectfully ask for your support. Thank you, and I close.
If there's no objection, House Bill 2243 will be left pending. Is there objection? to your next bill before I.
Okay. Well, I'm ready.
Back up, members. If there's no objection, House Bill 1290 will be left pending. Is there objection to that? Chair hears none. House Bill 1290 is left pending without objection. There we go. The chair lays out House Bill 2243 and recognizes Representative Campos to explain her bill.
Thank you, Chairman and members. Thank you for the opportunity to describe House Bill 2243 related to elderly assistance in obtaining a temporary ex parte order. This bill will provide added protections within the Department of Family and Protective Services to victims of an often less described type of family violence. HHSC reports that Texas is home to 3.7 million elders, 65 years and older, which is almost 13% of the total population. In 2022, there were over 80,000 elder abuse cases reported to DFPS. Adult Protective Services mission statement is to protect older adults and persons with disabilities from abuse, neglect, and exploitation by investigating and providing or arranging for services, if needed, to stop or prevent further harm. So while confirmed, victims of abuse may receive short-term help with shelter, home repairs, food, transportation, managing money, medical care, home health care services, and mental health services, an additional vital resource not prescribed as APS duties in court assistance. The National Council on Aging reports the predator is a family member in 60% of cases of abuse cases. 2/3 of predators are adult children or spouses. HB 2243 seeks to provide seniors who overlap the elder abuse definition and family household violence definition by requiring the department to assist them. Upon the senior's request in obtaining a temporary ex parte order against the alleged perpetrator, elder abuse, neglect, and exploitation is often overlooked and unaddressed in civil, criminal, and family justice systems, and adding this provision will improve systematic community responses to elder abuse. I am open for questions, and I reserve the right to close.
Yeah, you will certainly have it. Members, any questions? All right. There's nobody want to testify, but I just want to call up the resource witness. Chair calls Kez Wold. Thank you. We show you as Kez Wold, DFPS resource witness on the bill. Is that correct?
That is correct.
All right. Thank you. Would you walk through what y'all would be doing to help these senior citizens if this bill passes? Kind of how you would see implementing it? Because it shows no fiscal note. Don't think it's. So what changes in y'all's process?
So the fiscal note, we were unable to determine a fiscal note on this one.
Okay.
Because we weren't sure what it would garner as far as additional reports. Currently, APS, if we receive an allegation of abuse or neglect, we investigate. Our current policy requires the caseworker, if they identify abuse that may also fall within the definition of family violence, it requires them to explain that to the client and to, at that point, encourage the client to seek a temporary protective order. So we already encourage our clients. If they agree, we then assist them. We require our caseworker to assist them to file for a temporary ex parte order. If they agree but they don't want to sign, we actually have authority to sign for them on their behalf to file that temporary ex parte order,
okay.
Which we can and will do. So currently, we already do this on cases where we investigate. We did notice that the language of the bill would state that it's upon request of any elderly person. And so it sort of does, it kind of short circuits our investigation process, for lack of a better term. But we've had some conversations with Representative Campos' office on that issue. But that's sort of the process currently. Under the new bill, it could be interpreted to be any person who calls up and says, I'm over 65 and I want help filing an order. We might be obligated to help them file.
Okay.
So,
Might be good to clean up.
correct.
So, okay. But that's also, that's part of what we do here. So,
Absolutely.
okay. Members, any other questions?
I do.
Yeah,
So, first
Representative
of all-
Campos. Representative Campos.
Thank you for all y'all do, because I know that it's a tough job. And so the purpose, the reason I decided to file this bill is because I do a lot of groundwork, in my district and with seniors. And so I want to make sure that all seniors are protected. And what I have found is sometimes they're lost and unable. They don't know what to do. And so I just want to make sure that if we have an elderly individual that's getting abused by, especially a family member, that they know that there's resources out there and they can kind of go through the baby steps and y'all can guide them and make sure that they get the help that they need, because there is a lot of help out there. But, some of them don't want to speak up. And so I just want to make sure that the seniors are well taken care of, especially, I had one individual that was 78 years old in my district, and she was getting abused by her son, and it had been going on for months. And even the PD had gone out there, and she winded up having to, leave her home. So it was a really tough situation, and I've kind of seen that. So that's the purpose of my bill. And so I'm willing to work with you in any way to make it better. But I think that we just need to continue to protect our seniors. As we get older, our life should get easier.
Absolutely.
And thank you for everything.
I appreciate your interest, and I'm very familiar with that case and the outcomes, both good and bad. On it.
Yeah.
So I appreciate you I'll let my staff know that you appreciate what they do.
Absolutely. Please do.
Thank you very much. Members, any other questions? Thank you very much for your time. At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 2243? Seeing none, public testimony is closed, and the chair recognizes Representative Campos to close on House Bill 2243.
Thank you, Chairman. HB 2243 seeks DFPS assistance in elders obtaining a temporary protective order. Elder abuse is expected to statistically increase as our life expectancy does, and the legislator must add protections to victims who already constitute both elder abuse and family definitions. I respectfully ask for your vote, and thank you, and I close.
All right, if there's no objection, House Bill 2243 will be left pending. Is there objection? The chair hears none. House Bill 2243 is left pending without objection. 2 to go. Chair lays out House Bill 2307 and recognizes Representative Hull to explain her bill.
Thank you, Mr. Chairman, and members for allowing me to lay out HB 2307. This bill is a legislative recommendation by the Office of the Inspector General and clarifies how recoveries from Medicaid fraud, waste, and abuse are treated. Managed care organizations are required to refer suspected cases of fraud, waste, and abuse to the Office of the Inspector General. The OIG may decline to pursue a referral and leave it up to the MCO to conduct the investigation and make the recovery. This recovery is split 50-50 between the MCO and the state returns federal share on the recovery it receives from the MCO. If the OIG accepts the case and is successful in making a recovery based on this referral, the OIG and the MCO again split the recovery 50-50. The OIG then returns the federal share on the state's behalf. The bill clarifies that in both situations, the recoveries are to be treated the same way, which is current practice. The OIG has requested a statutory clarification due to the concerns that it could also be interpreted to mean that when the OIG recovers the funds, that federal share is paid on the full amount. This ensures we are continuing to incentivize fraud, waste, and abuse investigations to recover taxpayer funds. The OIG is available to testify should anyone have any questions, and I reserve the right to close.
All right, you will have that. Members, any questions? All right. Chair calls Rebecca Galinsky, is Rebecca Galinsky here? Okay, we will show her Is Rebecca Galinsky here? Okay, thank you.
Sorry. She was trying to listen.
Tell you what, I'm going to call Susan Biles, resource witness. Susan Biles listed with Health and Human Services Office of Inspector General on the bill. Is that correct?
Yes, sir.
All right, very good. How does this change? Yes, ma'am, and we will call you up next. You can come sit up front if you like, or wherever. So how does this change? Right now, does the MCO get anything when they find fraud or abuse? Do they keep anything?
So what this does is just clarify current practice. So right now, if an MCO identifies fraud, waste, or abuse, they refer it to the OIG. We can decline to pursue a case in which we send it back to the managed care organization, and then they pursue the case, or we can decide that we want to keep the case and pursue it ourselves. In either of those situations, the MCO receives 50% of what they recover, and they send 50% to us. Or if we recover, we keep 50%, and we send them back 50% of what they referred to us. The way the statute is written, you could interpret that if we do the recovery, that we pay the full federal share. We pay the federal share on the full amount. So if you have a $100,000 recovery, you would send $60,000 to the feds, and then we would split. So we just want to clarify that, as I described the first scenario, in either situation, we're splitting it 50-50.
Okay, and so just to be clear, you said you send 60% because that's the FMAP.
Correct.
That was the FMAP percentage. I was expecting 50, but you switched to FMAP.
Correct.
Okay, so you send the federal portion back, the state saves its 40%, approximately, right? Okay, and so what are the types of fraud in it? What's the most common fraud and/or abuse that you're finding?
So like upcoding is very common. I'm a therapist and I see someone for 30 minutes, but I charge for 60 minutes. Or you could have ghost claims where I never saw someone, but I charge for that. Or
Is that just, like in a case like that, where you charge and you didn't see, is that not criminal?
That would absolutely be something that we would also refer to the Office of Attorney General.
Because there's times where there's gray areas and then there's black and white. That's like, to me, totally black and white. It's, you can argue about charges or what the severity of something was. You start charging for something you didn't do.
If we have a
What's
case,
that? Right. It was, yes, theft. It's theft from other people that need the help.
if we have a case that we're taking to full-scale investigation, we also refer it to the Attorney General's office as well.
Okay. Okay. And okay, thanks. Members, any other questions? Okay, fascinating. Thank you very much. Chair calls Rebecca Galinsky. And we show you of Rebecca Galinsky testifying for yourself and Protect Texas Fragile Kids against the bill. Is that correct?
That is correct.
Okay.
Sorry, I was talking to one of the OIG members out there. So, good afternoon, Chairman Frank and committee members. I'm Rebecca Galinsky. I'm representing myself, my family, and Protect Texas Fragile Kids. We're a grassroots nonprofit group advocating for thousands of medically fragile kids and their families. Most of you each have constituents from our group in your districts. All of these families are on Medicaid waivers or on waiting lists for Medicaid waivers, so this would affect them possibly. I'm testifying against it as it is currently written, so I'll state it that way. If there's clarification, then that may change our stance on that. What I read and what it looks like is previously it was the amount recovered, and then the federal portion was taken off and the rest was split. And now it'll be split and then the federal portion taken off of what would come back to the state. So 50% going to the MCO off the top. So like the gross revenue versus net is the way I looked at it. That's the easiest way for me to think of it, as gross versus net. So if that's the case, then that means the MCO is getting a larger portion and the state is getting less because the state is having to pay out the federal portion.
I'm hoping we can get that clarified, because that's not what the resource witness just testified to. Now, that doesn't mean, resource witnesses make mistakes. And I think that, so I don't see that, but go ahead and continue.
Okay.
I'm sorry.
Well, and that's why, clarification would be good, because I was speaking with somebody from the OIG's office outside. They came up to talk to us, to ask us and question, why we were against it. And I don't like testifying against bills, and I don't want to be against a bill. So if we're wrong, then that's good. But I think with any bill, there's always unintended consequences, and the language has to be extremely clear and extremely explicit and directive to the agencies, because there's so many different agencies that are involved that are interpreting these things, that if it's not crystal clear, it can be misinterpreted where it's carried out in a way that wasn't intended. And the way that it's reading now, it seems like that's the case that could happen. I work in healthcare, so I know every year I have to do trainings on this from the OIG's office and things like that. And so the penalties that are charged to somebody who commits fraud, there's a penalty per offense of anywhere from $5,500 to $11,000. So if they upcharge 10 times, there's that fee times 10. Then for each amount that they charged, it's double recovery. So the amount that's recovered is more than what the MCO paid out for these services. So what's coming back in is a lot more. So our concern is that the MCOs are just getting a larger portion of that amount instead of that money going back to the federal coffers and to the state coffers, which as a taxpayer, I'm concerned with, because I want my tax dollars to go back where they belong, and to go back into the state program from which the money originally came from. Because if it was paid out of this Medicaid program and the Medicaid waivers, but it was a fraudulent charge, then that money should go back into that program that it was taken from initially, and that doesn't appear to be what's happening here, or at least not the full amount of it. So it seems like it rewards the MCOs for this, even if they aren't doing the work of the investigation, is what it appears on this bill. And that's also concerning, because I handed out, I gave a handout that shows the FSRs for fiscal year 2021 of the MCOs, where they had record-breaking profits. Okay. So on each of those figures on the chart, it's been shortened, and you add 3 zeros to the number you're looking at. So it's record-breaking profit, and if that's the case, why are we giving them more versus putting that money back into the Medicaid program?
Okay. Thank you. Members, any questions? Yes, Representative Ramos.
Thank you, Mr. Chairman. And pardon me, I just came to the last, I just stepped in, but is what you're referencing where the bill cites that the MCO, the organization, is entitled to 1/2 of the amount recovered for each payment?
Mm-hmm.
So that's where, no matter what it is, like you're saying, it's just whatever they identify, they get 1/2 off the top. Is that what you're reading?
That is my understanding of the way it's written, where the lines, where what was taken out, said that it was 1/2 after the federal, which the federal matches dollars. So the federal government's going to get their money one way or the other. So it's saying that they're taking it out of that top, out of the gross.
Right.
And then the net is being split between the MCO and the state. What it looks like it's changing it to is they're getting 50% of gross.
Right off the top. That's,
Yeah.
I read that as well. Thank you.
Okay. Thank you. So is that from a reason that you're against the bill? If that were not the case, I don't think that was from the testimony, that wasn't the intention. I think the other person thought it's not the way it reads. I kind of agree with you in terms of the way it reads.
And that's where I think it may
Right.
have unintended
So-
consequences.
Well, that's just,
that it's not clear.
that's potentially bad wording. I don't
Yeah.
know that that's unintended consequence. That's just, and I'm not trying to parse words, but that's just not doing what we're saying, what we're trying to do with the bill, at least according to the bill author and the resource witness. Is that your only problem, or your organization's problem with the bill, or is there something else?
I mean, honestly, if the MCO isn't
That's
the
what
one
we're
doing
going
the
for.
investigation, if the MCO isn't the one doing the investigation and they're not putting anything out there,
then they should recover what they lose. You know, if they paid out, they should get back what they paid out that was fraudulent. But I don't think they should be getting back extra if the OIG's office is the one doing the investigation and paying for the investigation, which is costly because it is not a quick investigation. They're lengthy. They're paying those attorneys to investigate it, but the MCO is getting more than what they paid out. So I don't have a problem with them getting their money back. They should.
Right.
But my concern is just how that's being divvied up. And if the state is paying out more money to investigate this than what we're getting back, then we're losing money for each one.
Right. And I think the one difference, at least with the way the MCO contracts, most of them have, we end up sharing part of their profits if they are doing their job well. And honestly, you do want, and I'm not saying that numbers are exactly where they need to be, but you want them incented to find fraud. And I think whether it's exactly divvied up right or not, but Representative Noble.
So you probably don't see the bill analysis that we see, but it's the MCOs that are actually sending the OIG the tip. They're the ones that are alerting the OIG. The OIG is not going out and doing these investigations on their own. So actually, it's them that are sending the fraud or abuse referrals to the OIG. So that's why they have buy-in. Initially, I hope I'm not missing something here, and that's why they're not only are they paying out, but they're also the ones that are on the front line seeing that it's happening, and so I'm grateful for them and for their doing that, and for the OIG for doing the investigation that's given to them. Am I missing something here?
I was going to say, as an individual, I can also initiate an investigation. If I see fraud, I can contact the OIG's office and say, hey, I see fraudulent charges. Would you please investigate this? I actually did that with my mother on Medicare. She had charges that were coming on her that were being billed, and she was being denied a service that she needed because they said she had just had it. And we're like, no, she didn't. And so I had to go through the federal OIG's office to report that. The state, as an individual, if I report that to them and the OIG's office chooses to take that on and investigate it, I can get back part of that money as a reward for reporting it, but it's like 15 to 20% versus 50 that the MCOs are getting. If I do that on my own, if the OIG decides they don't want to take it on, and I decide I'm going to hire an attorney and I'm going to pursue this myself and I win, then I can get 25 to 30% of those what's recovered back plus attorney fees. So why is it for an individual so much less than what it is for the MCOs? There's a disparity there. So
yeah, that's a very fair point. I'm trying to get and understand the Texans for Fragile Kids. Like, is this harming those kids? I mean, because you made some great points. I'm trying to figure out from an organizational standpoint, is this something y'all are concerned about with those kids?
a couple of things to that. One, our kids were thrown into the MCO pool when the state moved it to that from the fee-for-service, supposedly to help reduce fraud, waste, and abuse. Unfortunately, our group of kids, that's not been a good fit for them in that program because there's services they're not getting that the MCOs are getting paid for and the kids aren't getting. So in a way, to me, that's almost like corporate fraud where they're getting paid for it, but they're not paying out. So it's like state sanctioned in that sense. So our kids are penalized that way. But also, I mean, there are things that happen that are fraudulent. But if the MCOs are incentivized to look for fraud, are they going to look for fraud that's not fraud? You know what I mean? Like if you're specifically looking for something, you're going to see more of it. But it may not really be. And that's my concern is it incentivizing them to go after it too much? Because then it would penalize our providers to the point we may lose more providers. And our access to care is already very limited. There's not enough providers as it is. So my concern is we could lose more providers if it's not run correctly. And so I don't want it to incentivize them to the point that they are looking for it over and above what it should be.
Okay. Thank
Does
you.
that make sense?
Sure.
I hope I'm explaining that correctly.
Thank you. Members, any other questions? All right. Thank you.
All right. Thank you.
Yeah, Chair calls Susan Biles back up. Resource witness. And I've got you as Susan Biles, Health and Human Services, Office of the Inspector General on the bill, correct?
Yes.
Okay. Representative Hull?
Thank you. Can you, again, kind of explain and clarify what is in statute now, what current practice is, and what this is doing, and
Absolutely.
and address the concern they're saying of striking that?
I think this conversation is exactly why we asked for the clarification, because you can look at the statute and you can read it in two different ways. So current practice is that if an MCO sends us a referral and we accept it and pursue it, we send the MCO 50% of what we recover that was part of their referral. We keep 50%, and then we pay the federal share on that 50%. So we're not in a situation where we're changing it from we pay the federal share on 100% of what we recovered and then split it. We are currently now sending them 50% and then paying the applicable federal share on our 50%. And so I think the confusion that we're seeing in reading the statute is why we're asking for the clarification.
I'm having trouble with, and I'm sorry, because I'm having trouble with the way it's written now. So I guess, I'm assuming, have y'all's lawyers looked at this?
Absolutely. We have had many, many discussions.
Okay. Well, I just think we need to get, and we can do that offline, we just need to make sure there's good clarification on what it actually is. Were you done, or with her, rather? Go ahead,
Really?
Representative Hall.
So the language and what you're striking and all of that is just to clarify what current practice is?
Correct.
Correct. Okay, and so y'all aren't trying to change anything, you're just wanting to clarify what is currently happening to make it clear in statute?
Correct.
Okay.
And just to be clear, if a MCO gets 50%, is it true if I'm an individual and I turn in, is it they get 20 or 25%, they get a lower amount?
If an individual reports fraud, they're not receiving a percentage of what the state recovers.
Okay. Yeah, Representative Ramos.
I think she was referencing a private civil claim against,
Oh, okay.
probably, I think that's what she was referencing, which
Thank
would
you.
be the standard, I guess, about 30%. But to be clear, and I think that's the problem, right, it's not clear. So that kind of, we're kind of starting back at the beginning, but did you say, did I hear right, 50%, the MCO receives 50% of what you recover that was part of the referral, and then the state pays the federal share out of their 50%.
But the federal share is only assessed on the state's share. So from a math perspective, if you have a $100,000 referral and we recover $100,000, the MCO would receive $50,000, the state would receive $50,000. We pay federal share on $50,000.
So it goes back to the concern of the prior witness that they get 50% right off the top. That's exactly how this is written, right? That's what the intention.
Yes, but if you interpreted it in the other way, if you had a $100,000 claim, you would send $60,000 to the feds, and the state would retain $20,000, and the MCO would retain $20,000. If the state only received half, 50%, we would send $30,000 to the feds. We would keep $20,000. The state share is not impacted in either scenario. It is the MCO that receives less if you pay the federal share on the full amount.
So the goal of this bill was to give the MCOs more.
The goal is to clarify the practice of what we currently do. When this bill was passed in 2017, the MCOs received 100% of any recovery in managed care. And so this actually gave the state money when it received none before if there were recoveries in managed care.
Okay, thank you.
So just to be clear, it is clarifying, you feel like, although I don't know that we feel like it's clarified, but the attempt is to clarify existing practice, not change existing practice.
Correct.
Okay. And then the last thing, because we don't deal with this subject matter very much in here, and I do think it's important. The MCO is already supposed to be in their management process preventing fraud, right? They're managing the they're managing their providers. They are, they have checks and balances in place. What is it that we expect them to do on an ongoing basis versus finding out afterwards? Do you know what I'm saying? I mean, they're already
Like prevention or.
yeah. I mean, they're supposed to be making sure that they're working with good providers, and they have standard practices. You also don't want this perverse incentive of, hey, pay it all out and I can go collect on the back end. So, how do we determine what they should have already done in good business practices as they manage the care versus, oops, I found a fraud?
Well, I would say I would leave it to the MCOs to tell you what all of their business practices are that they do to do cost avoidance. They are required to have what we call a special investigations unit. So they have investigators and they look at data analysis in the same way that the state does in order to identify fraud, waste, and abuse. They do things that the state does as well, like having edits in place to prevent, billing that's inappropriate. But I would leave it to the MCO to
Okay.
give you more information about all the things that they're doing.
Although honestly, I think it's a state and our state contracting practice to tell them what is expected versus what is.
Well, and I think through they have to have a compliance plan, which identifies all of those
Right.
different kinds of things. They have their investigators and those kinds of things.
Yeah. Okay. Thank you. Members, any other questions? All right. Thank you. Sorry, I got out of place. Showing what's that? Yep. This one. At this time, there are no other witnesses signed up to testify. Is there anyone else wishing to testify on, for, or against House Bill 1085? Seeing none, public testimony is closed, and the chair recognizes Representative Hull to close on HB 2307.
Thank you, Mr. Chairman and members. Hopefully, after she came back up, that kind of explains all of that with how much is going where and what's already happening. Hopefully, that has been clarified. So I ask for your favorable consideration. Happy to answer any questions, and I close.
If there's no objection, House Bill 2307 will be left pending. Is there any objection? Chair hears none. House Bill 2307 is left pending without objection. The chair is going to hand the gavel over to the Honorable Tony Rose. Is that prepared? Oh, do you want to go right here? Or do you want to?
Going down there?
No, I was just going to sit up here.
Okay. We'll just put it over.
Okay, there you go. All right. Tony.
Excuse me. The chair lays out House Bill 1517 and recognizes Chairman Frank to explain his bill.
Thank you. You got to admit, we at least make everybody smile and laugh a lot up here. So that's good. That's good. I appreciate the opportunity to talk with you all today. Anyone who's ever cared for children in the foster care system know that kids can be a challenge. The only thing more challenging than the kids in the foster care system is working with the state in some of the requirements, and I think that is true. Oh, that's
Chair Frank, I understand you intend to have changes to this bill. You may explain any changes that the substitute will make, and the substitute language will be distributed after the hearing.
I will do that.
Okay,
Thank you, Madam.
thank you.
Thank you, Madam Chair. Really, what we're asking to do in this bill is under HB 1517, the state is being asked to engage with an independent third party to conduct, and right now it is called an audit, and I'll tell you about a change, but an audit of the rules and regulations governing the provision of foster care and adoptive services. An independent third party is required to deliver recommendations for how the state can simplify and streamline the regulatory landscape in a manner that prioritizes child safety and reduces barriers to entry for prospective foster families, adoptive families, and child placing agencies. The bill requires that DFPS and Health and Human Services jointly develop an implementation plan for recommendations. My hope is that it will promote the safety and well-being of children in the foster care system and ensure sufficient capacity. You know, one of the challenges is we add stuff year after year after year of things that should be done, and I won't go into all of them, all of the things that can happen that disqualify people or providers from being foster care providers, but we've had, we had a military couple in Wichita Falls that wanted to be foster parents, were very well qualified, but lived in base housing, couldn't make some minor modifications to their house, and so they are disqualified from being foster parents. And because it's a rented house, and they can't, normally you go, I'm going to spend $2,500, which is a lot of money, but you can make those if you really want to be a foster parent. And there are things like that are well-intentioned, but what we're trying to do is have both agencies go through and inventory all of their rules and streamline. I've had discussions with both commissioners on it. I think there's buy-in on behalf of the agencies to actually work with a third party. I don't have in mind who the third party is. Do have a fiscal note for $1 million because it is, and honestly, I've already started the process of trying to get the $1 million. We will, in a possible committee sub, we would give them the ability with other funds if we don't get the $1 million, but I think we will get it because I think there is a need. This is actually something that I have tried various ways to work with the agency to try to streamline, because this is another one of those things, frankly, that we can do. It's just in the normal course of events, it's hard to ever sit down and actually look at all of your processes, and there are thousands of processes. And so it sounds ridiculous to spend $1 million on it, but if you look at the complexity of both agencies, particularly working together between the licensing and DFPS, that was the number that between the commissioners and myself, we felt like was a good number and could get a solid, could look at all of them, lay them out. And then the responsibility of the agency is within 90 days of receipt of that is to respond in writing. They do not have to follow all of the recommendations. They do have to respond to all of the recommendations. It's just because you write them a big check and they give you a recommendation doesn't mean that everyone is going to be a good one, but they need to respond to every single recommendation. Y'all might wonder, there's a really good chance it'll be a university. It's actually easier through the procurement process to be a university. It could be a third party with a rider, but it will likely be a university, one of the state universities, but that's undetermined. It could be either one. So in terms of the changes, there's just a couple things that the biggest one was instead of an audit, it will be called an assessment. An audit, I didn't know, but an audit triggers a very specific thing within state government that we're really not trying to do. We're not trying to do a full-blown audit. We're trying to do an assessment of and a streamlining of the regulatory guidelines. Yes, it will be focused on child safety. I will tell you, though, the more barriers you put in front of good providers and good foster parents, if they're not intelligent, then you're actually getting worse people, not better people, with the higher criteria. My least favorite, most favorite example is a quarterly inventory of clothing that you're required to fill out as a foster parent. And it's just kind of, yeah. So I have told the story, but for the new members, we were adopting on the 5th of the month, and like the day after the end of the month, we got a call saying, hey, where is that clothing inventory? I'm like, we're adopting them in 4 days. My wife's counting dirty socks and that is a true story. And it's in all of those things are put in there for good intentions, and but this is 30 or 40 years of good intentions has created a pile of work on the providers and foster families, and so we just want to try to go through there. We'll see the recommendations, and we'll have a chance to act on them. Anything that's in statute would have to be cleaned up next session. If it's in statute that it's required to do and somebody recommends that it be removed, then we would have to fix it in statute. A whole lot of these things have just been promulgated by rules. So the rules they could change on their own. Any statutes we would have to act on, and it won't be till next session. So there are some, I'm not going to call witnesses, sorry. With that, Madam Chair, I'd be happy to answer any questions.
Thank you. Members, are there any questions for Chairman Frank? Representative Noble.
I think this is a fabulous bill. And my foster parents in my area will be so excited to hear that something's like this is happening. My question is, are any of our rules that we have federal rules, or is it all us as a state?
No, there are absolutely many of them that are federal rules, and obviously we won't be able to waive the federal rules. The implementation of the federal rules, I think we can
look at those.
Sure, okay. We can look at those. And I know there are resource witnesses. But yeah, the federal rules, well, I'm not going to say they're guidelines, but yeah, we have to follow the federal rules. But I think the way in which we follow them don't quite have to be so onerous, I think, many times.
Representative Ramos.
Thank you, Madam Chair. My question is, this looks like a great bill. I actually have, I spoke to you about some constituents. Yes, you actually have a good idea.
What is today's
What is today? Thank you. Today is
At
March 21st, baby.
2:31
Write that down.
p.m.
All right.
You guys are crazy. I spoke to you about my constituents, my neighbors, who they almost did not want to complete the process because of these it seemed like it was just extreme nitpicking. It was thank goodness they went through and they have two beautiful little boys in their home. Are some of these rules beyond the state and implemented or enforced by agencies like the specific providers?
Absolutely.
And not the state?
I'm sorry.
Yes.
Yeah, absolutely. They are enforced by the agency. I will say, though, sometimes that is because of insurance requirements. And you know, and this is a tough subject. It's not really this, but if you're putting particularly the higher acuity kids, the more challenges you have, right? You say, hey, take care of a child that is, abused and sexually abused another child, and then you give them no protection while they do that. Their insurance company is going to not only charge them, they're also going to say, well, you must do this, and so it can be added from any level. And again, some of these things we want to protect kids, right? But we want to do it intelligently. And I don't know, this is certainly not the end all be all. They won't catch everything, but I'm hoping that we can catch some of it.
Understood. Thank you.
Yeah, thanks.
Thank you. Any other members? Okay. The chair calls Jamie McCormick with the Texas Alliance of Children and Family Services. Thank you for being here today. We show you as being for the bill. On behalf of the Texas Alliance of Child and Family Services, and you will be testifying for the bill. Oh, is that correct?
That's correct. Thank you.
It's late.
It is. Thanks for having me. I'll be quick, I promise. Honestly, my name is Jamie McCormick. I'm with the Texas Alliance of Child and Family Services. Chair Frank did a wonderful job laying out that bill, and our members represent the organizations that provide child welfare services across the state, foster care, adoption, prevention services, and in particular, those that are regulated under the entities described in this bill. We are very, very much in favor, as Chair Frank described. We're sort of under this more is better philosophy right now, and what that tends to do is we are adding on layers where we're starting to focus so much more on compliance than we really are about kind of the care and treatment of kids. And we really want to recenter to focus on those core safety principles, but also making sure that we can adapt and make sure our foster homes can adapt to meet the needs of those kids. We do have a lot of kids in care that are high needs kids, and sometimes just the layers and levels that we have to go through make it really difficult to care for those kids. And we want to make sure that they're the right people, that they're the right services, and that they're safe. But we've got a little bit of work to do. Our system has really gone through some transformational changes over the last 5 years or so, and but our regulatory system hasn't yet adapted to that. We think this is a great opportunity to do that, and we're excited about the approach. Happy to answer any questions, and I did want to note the handouts that we gave. You'll hear from Buckner today, who's a provider, but we've also got 3 member providers that have offered letters in support. They're very much excited about this, so thank you so much. Happy to answer any questions.
Thank you. Members, are there any questions for the witness? Thank you. At this time, the chair calls Andrea Sparks, who is representing the Buckner International. Oh, that's my friend. Hey, from Dallas. Okay, Ms. Sparks, we show that you are registered on behalf of the Buckners International, and you're testifying for HB 1517. Is that correct?
That's correct.
Okay. Go ahead with your testimony.
Thank you, Chairman, for this bill. Thank you, members, for having us. We have been caring for children for 144 years in the state of Texas, and we absolutely understand the need for protections and accountability for our children. But a new set of standards can achieve that without driving potential foster parents away or discouraging normalcy and trauma-informed care in residential settings, and blocking kinship families from getting licensed, even though that license would mean much more financial support and services to help them and the children in their home. For example, why do grandparents have to take an annual course on cybersecurity? Why can't a caregiver sleep on a pull-out couch? That's what they have, or turn the dining room into an extra bedroom. Sure, we can and we do apply for variances for these kinds of things, and we get them, but that process takes away from the work we need to do to help these relatives care for the children. And it's very frustrating for kinship families when they want to do the right thing, and it's these little things that get in the way. We're very hopeful about the provisional license for relatives that was in SB 1896 that Chair Frank sponsored, and I've heard that that work is happening. We're providing input on that. And we're also very hopeful that the feds have recently started asking about the potential to do a separate license for kinship families, which gives us a lot of hope. We're licensing more and more relatives. But even for non-relative foster parents, we do need reform. The way that licensing monitors now for standards can seem like a gotcha for our foster families. And it's very frustrating, and frankly, it can seem very disrespectful, like y'all said. Just an example of one of our foster parents in a rural area had a locked tool shed, as required with all of his tools, but he happened to be outside doing work in the yard that day, and when licensing showed up, the tool shed was not locked at that moment. And so he was, we were written up for that. And it's just a shame because this is a foster parent trying to do the right thing, and he was locking the tool shed as he should. And if there were a way to look at how we monitor for licensing violations and look at overall how the family's doing instead of just a point in time, that would really help the process a lot. And that's all I have. Thank you for allowing me to testify on this important bill.
No. I forgot I had the chair.
And
all right.
I've got to say,
Members out there.
Talking all the time.
can I just add one thing? I'm sorry I had
please.
to wear my raincoat up here, but y'all, it is freezing in this room.
Tell us about it.
That's out of line.
Members, are there any questions for Ms. Sparks? Okay. Okay. All right. At this time, Andrew Brown. Okay, come forward, please. Please state your name and who you're representing.
Good afternoon. Andrew Brown with the Texas Public Policy Foundation, testifying in support of House Bill 1517. Responsibility for overseeing the Texas child welfare system is shared between the Health and Human Services Commission as well as the Department of Family and Protective Services. To make a very complex system a little bit more simple, HHSC is responsible for promulgating the rules, what we call minimum standards, governing the operation of child placing agencies as well as residential programs, while DFPS is responsible for contracting and ongoing monitoring of service providers, foster families, kinship families, and adoptive families who are licensed by the state. Overlaying these baseline regulations, as Chair Frank mentioned, are federal rules, which we can't do much about, as well as directives issued from monitors appointed by the federal judge in the ongoing MD versus Abbott lawsuit. So all told, anyone wishing to serve children and families through our child welfare system at any given moment could be subject to up to 4 layers of regulation. And each of these layers don't often talk to each other very well. They're siloed. And while protection of children in the care of the state is of the utmost importance, because of the current regulatory landscape, which has been described as inefficient, disjointed, and confusing, we're often getting a contrary result. The environment has actually led to the withdrawal of a number of high-quality providers who have determined that it's simply too burdensome to operate in Texas. What we appreciate appreciate about House Bill 1517 is not only that it seeks to streamline and simplify this regulatory environment, but as you read through the bill, you'll notice that each of the deliverables that we're requesting from this third-party evaluator has a specific purpose in mind. For example, if we're looking at easing ongoing licensing, training, and oversight requirements, well, we're looking to ease those things that are acting as barriers to retaining high-quality foster, kinship, and adoptive homes. We want to provide maximum flexibility for the application of standards so that services are responsive to the unique needs of children in the care of the state. I think this is an important detail of the bill because it tells that contractor exactly what we're trying to do, what goals we're trying to accomplish, and will direct their recommendations towards achieving those goals. We thank again Chairman Frank for bringing this important bill. We think it will be an effective tool in the ongoing work that you all have done such a good job at of improving our foster care system in the state. And I'll be happy to answer any questions you may have.
Okay. Thank you, Mr. Brown. Members, do you have any questions? I do. Next time, if I ever, can you all make me one of these fancy pamphlets for one of my bills?
I'll stop by your office after the
Please,
hearing.
let's work together. I want one of these fancy.
I'm just going to bring an order form to all the
Okay.
hearings.
Thank you, Mr. Brown. Okay. Is that the last one? Okay. Is there anyone else here who wishes to testify on, for, or against House Bill 1517? Seeing none, public testimony is closed, and the chair recognizes Chair Frank to close on House Bill 1517.
Thank you very much, Chair Rose. I'll be brief. If any of y'all are on, any of y'all on appropriations? All right. Well, no, I would appreciate your favorable consideration, and the money to pay for it would also be most appreciated. So with that, I close. Thank you.
All right.
What you got?
Oh, if there's no objection, HB 1517 will be left pending. Oh. Is there any objection? Okay, the chair hears none. House Bill 1517 is left pending without objection. It's been a long day.
I understand.
It's early, but it's still been
Love you,
a long
Tony
day.
Rose. All right. Oh, sorry. Thank you. Oh, be still my heart. All right, thank you. Thank you. Thank you for all witnesses for being here today. Members, that concludes today's agenda. Is there any further business to discuss? I hear none. If there's no objection, the committee will stand adjourned. Subject to call the chair. The chair has no objection. The committee is now adjourned. Thank y'all.